Hello everyone, welcome to the channel. My name is Monica and I welcome you all to UPSC Warriors by an Academy. How is everyone doing? Just tell me in the comment section if the audio and video is working fine so that we can start with the session. Come on. Hello Purti, hello. I guess the audio is video is working fine. We can start the session now. Yeah, looks good. So this is our third session. This is third class of our, class 3 of Polity. And we have discussed Constituent Assembly and some part of Preamble already. So if you haven't watched those videos, you can watch it after the session and make the most of these series. This is beneficial for people who are preparing for UPSC CSE 2025-26, and for people who want to revise polity, this is the right platform for you. You can brush up your polity because we are doing PYQs also. Yesterday also we did PYQs, and today's session also we are gonna cover some PYQs related to Preamble. Yesterday we did for Constituent Assembly and for Preamble. Today also some part of Preamble we are gonna cover, and hopefully this session will be beneficial for you all. So the plan for the channel I'm gonna discuss for polity, and then we'll proceed with our class. Let me see. Okay, all clear, all clear. So we can begin. The plan is pretty simple. We'll take live classes. This is our third class on polity. The plan is to take 5 classes per week, and we'll cover important constitutional articles starting from Article 1. As of now, as I've mentioned before, we have covered Constituent Assembly and PYQs on that. We have covered half of Preamble, that is the term sovereign, secular, socialist, democratic and republic, and PYQs on that. The other half of the Preamble we are going to discuss in today's class. This is designed in such a way that it is beneficial for your prelims as well as for your mains, and we'll cover current affairs also. Yesterday I mentioned that Maharashtra government and Karnataka government has included reciting of Preamble in schools and colleges. So that is an interesting current affair update that you can mention in your answer. Today we are going to discuss half of Preamble. So this is the plan for the channel. Hopefully you get it. And now the other half of the Preamble we are going to discuss today. So today also I'm going to share a very interesting fact with you. I have mentioned it earlier that Preamble is the first thing that you see when you open our constitution. Preamble in general means introduction or a preface to the constitution. American constitution is the first constitution to have preamble. Indian constitution also have preamble. So it is the first thing you will notice. But do you know that preamble is the last thing that was added in our constitution? Our constitution makers voted on preamble at the very end. That is because they wanted to make sure that the entire constitution and preamble has the same ideals and principles. They wanted to make sure that the preamble is in conformity with the entire constitution. Preamble reflects the ideals and the principles of our nation, of what India wants to be. And the entire constitution is a way of doing it. So they wanted to make sure that they both are in sync. So the first thing you notice in our constitution is preamble. The first page is preamble itself. But preamble was added at the very end in the Constituent Assembly. Now you must be confused because I mentioned this before, that preamble is a kind of the foundation on which preamble is made is objective resolution, which was introduced by Jawaharlal Nehru. Objective resolution was passed in 1947 itself, but objective resolution is the basis on which preamble is designed. They both are different documents. So preamble is voted upon at the very end. Now we'll have a look on the preamble and we'll discuss the rest of the things. We have discussed the source of the authority, that is the people of India. We have discussed these terms: sovereign, socialist, secular, democratic, republic. This is the nature of India which was there. Now we need to discuss the rest of the preamble, the objectives which we want to be included: justice, liberty, equality, fraternity. These are the objectives which we want to be included in the constitution. So there are some types of justice mentioned here. So these are the terms we are going to discuss in today's lecture, and we'll do PYQs on that. And the words in green represents what? The words in green are the 42nd Constitutional Amendment Act, which added 3 words in our preamble, that is socialist, secular and integrity. Before that also, rest of the preamble was as is. This 42nd Constitutional Amendment Act in year 1976 added 3 words, socialist, secular and integrity. Now moving forward, I just want to highlight that these are the terms we are going to discuss. So we'll proceed with that. Justice. We'll start with the word justice. The idea of justice is borrowed from Russian Revolution. Russian Revolution introduced the idea of justice, and Indian constitutional makers borrowed this concept from there. We have 3 types of justice. Here it's written social, economic and political justice. 3 types of justice is there. Social justice means equal treatment to all citizens. Equal treatment to all citizens means that we are not gonna discriminate our citizens on the basis of caste, gender, race, religion, sex, etc. So there will be equal treatment. There won't be any discrimination on the basis of these things. Next type of justice is economic justice. On economic justice, we want to reduce the inequalities in terms of wealth, income. We want to reduce this economic inequalities. There is a way of doing it. We reduce economic inequalities via tax. We tax the people with higher income and we redistribute this income among poor. So economic justice is reduction of inequalities in terms of income, wealth, property. And the third type of justice is political justice. Political justice means that we want equal access to political offices, political rights and equal voice in the government. Now, one thing you need to remember is social plus economic justice is called distributive justice. Social plus economic justice is called distributive justice. So Indian Constitution or Preamble of Indian Constitution has 3 types of justice: social, economic and political justice. Social and economic justice cumulatively called distributive justice. Okay, hope it is clear so far. Now moving forward, the next term we are going to discuss is liberty. Liberty again itself is a very all-inclusive term, and we are going to define what, we are going to explain what it means, and then we'll differentiate between liberty and freedom. So liberty is freedom from restrictions. You don't have restrictions, you can do whatever you want. But is it that absolute in nature? Can we really do whatever we want? It's not always the case. We can't do whatever we want always. For example, if I want to play loud music at midnight, and irrespective of the place where I am, for example, I'm in a hospital and I want to listen to loud music, can I do it? It's not an absolute power. It's not completely free from restriction. So liberty is not an absolute thing. It's not absolute. It's not absolute in terms of restrictions. There is not absolute freedom from restrictions. It has some limitations, but it provides us the opportunity to develop our personalities to the best of our capabilities and potential. So liberty is freedom from restriction, but with the avenue to promote our personality to the best of its potential. There are 2 types of liberty: positive liberty and negative liberty. Negative liberty means that absolute freedom from restriction. You don't have any restrictions. This is an absolute concept. On the other hand, the political analysts and thinkers realized that we don't want this type of liberty because it is derogatory or it has its own problem and it is undesirable. The reason for it is, for instance, if someone has absolute liberty, that means that this person can kill someone also. So this is not the sort of freedom that we are expecting. So that's why we leaned towards positive liberty, where there are lack of restraints, but there is state which interferes or tells you or restrict your liberty to some extent so that you can make the best out of it. Later on, political thinkers agreed on the fact that absolute lack of restraint is neither possible nor desirable. It is not desirable to have complete lack of restraint. That's why we introduced the concept of positive liberty, where state somehow restricts something, but these restrictions are reasonable. Now, Preamble provides liberty of thought, expression, belief, faith, and worship. These are the things which Preamble provides. Liberty to that is, we can think whatever we want. Expression, belief, faith, and worship. This is the word that Preamble has written there. But one thing we need to understand, that Preamble has used the word liberty and not freedom. The word freedom is not used in the Preamble. It is used in the Constitution with respect to freedom of speech, freedom of religion. But the word here is the word in the Preamble used is liberty. Again, as I've mentioned, it is not absolute but qualified. There are restrictions to this thing. So this is what we know as of now. Now, I have told you that there is a difference between liberty and freedom. We need to understand that. I can explain it through a very simple example, that is of our freedom struggle. Our freedom struggle, that is, we want British government to leave India, is called freedom struggle and not liberty struggle. So there is some difference between freedom and liberty. The difference is very simple. When you want to get rid of an external control, you use the word freedom. When you want to make the best of your personality, when you want to grow or develop your personality, you use the word liberty. So freedom is getting rid of external control. Liberty has to do with internal drive. So that is the difference. Preamble has used the word liberty. On the other hand, the Constitution has also used the word freedom. Moving forward, we'll solve a question now. Read the question. Which of the following reflects the most appropriate relation between law and liberty? Okay. Those of you who have joined, can you answer this question? What is the appropriate relation between law and liberty? This was asked in the year 2018. UPSC Prelims. It's a very interesting question and it can be solved through elimination. Can you give me the answer if you know what it means? If there are more laws, there is less liberty. If there are no laws, there is no liberty. If there is liberty, laws have to be made. And if laws are changed too often, liberty is in danger. What could be the answer? Okay, I'll solve now. The relation between law and liberty. Let's read the options one by one. If there are more laws, there is less liberty. It is not always the case. For example, we wanted sati to be abolished. So what we asked, to make a law about it. So at times, laws provides more liberty. Sati abolition was a law, abolition of sati. Okay, so option 1 is not always correct. So we can eliminate this one. If there are no laws, there is no liberty. Is it the case? We'll come to it later on. If there is liberty, laws have to be made by the people. Now, if there is liberty, laws have to be made by the people is a bit stretch. Because monarch also can make laws. It needs not to be always democracy. So if there is liberty, law have to be made by the people is a bit stretch. That's why we can eliminate this option. If laws are changed too often, liberty is in danger. Is it the case? If we are making a lot of constitutional amendment acts or coming up with a lot of laws, does that mean that we are taking away the liberty? It may not always be the case. At times we are making laws to get some liberty. So this is also wrong. So the answer is B. If there are no laws, there is no liberty. There needs to be laws to ensure that other people's liberty is not encroached or is not gone. So that is the answer. The answer to this question is B. Okay, there is one more question. In the context of polity, which of the following would you accept as the most appropriate definition of liberty? Out of these four, this was asked in 2019. Which of the following is the most appropriate definition of liberty? Try solving this one. Hello Meenal, welcome to the session. Yeah, the answer to that was B. Solve this one. Protection against tyranny. Tyranny is oppression. Tyranny of political rulers, absence of restraints, opportunity to do whatever one likes, and opportunity to develop oneself fully. What does liberty means? Okay, I got the correct answer. The correct answer is D. Opportunity to develop oneself fully. It has the absence of restraint. Do we offer complete absence of restraint? No, so we can eliminate this option. Opportunity to do whatever one likes. It's not always the case. What if I want to kill someone? So I can't do that, no? So there are some restrictions to it. Opportunity to develop oneself fully is the answer. So answer to this question is D. Moving forward. Now we have discussed justice and equality, justice and liberty. We are going to discuss the term equality now. Equality means absence of privileges. There is no privileged class in India. We don't offer extra discounts or extra benefits to anyone. We are all equal. That means that we have equality of status and opportunity. All are equal in the eyes of law. Also, we have equality of opportunity, which means that we have equality of opportunity in terms of public employment. We have equality of opportunity in terms of education. So this is what Preamble offers, equality of status and opportunity. Now there is one more type of equality, which is equality of outcome. India don't have it. Equality of outcome means no matter whatever you do, you'll get the same result. For example, if a person who doesn't do anything and is unemployed, on the other hand, if a person who is a scientist and who works really hard gets the same salary at the end of the month, is it fair? The outcome of their events are same in this case, and it's not justified. So India doesn't follow equality of outcome. We have equality of status and opportunity. Now there are three dimensions of equality. As we have studied the dimensions of justice, there are three dimensions of equality: civic, political, and economic. Civic equality is given under fundamental rights, article 14 to 18. We'll discuss them. It usually means that equality before law, abolition of untouchability and stuff like that. So we'll discuss it in fundamental rights. Political equality means universal adult franchise. That is, we have been given the right to vote. People above 18 years of age can vote. Then we have economic equality also. In this, I want to discuss wage parity. Economic equality means that men and women have equal opportunity of livelihood. Also, men and women are paid same for the same amount of work. So, it is achieved in India or not, that is the case, and it is up to the discussion, because we generally see that men and women don't get equal wages for same amount of work. So that is why economic equality means we strive for wage parity, similar wages for men and women. It is a work in progress, and we have seen a protest in Iceland about this thing also, where the Prime Minister also was a part of this wage disparity protest. Moving forward, we have discussed equality. Now we are going to discuss about the term fraternity. Fraternity means sense of brotherhood. Sense of brotherhood. So we promote a sense of brotherhood through single citizenship. Our constitution offers single citizenship. We don't have the concept of dual citizenship. That is, we are given a same citizenship. We don't have citizenship on the basis of states within India. We are all Indians, so we have single citizenship. Fundamental duties also talks about sense of brotherhood or feeling of harmony. Now there are two more terms to discuss in fraternity. That is, fraternity has to assure dignity of the individual and unity and integrity of the nation. So let us understand first dignity of the individual. K. Munshi, who was the member of the draft committee. I have discussed that the chairperson was B.R. Ambedkar. The member of the draft committee, one of the member was K.M. Munshi. So he explained that when it comes to dignity of the individual, it is not confined to material betterment. That is better standard of living. It's not just that. It is much more than that, where we offer respect to the individual's personality also. So dignity is a broader term. It not just includes material betterment. It includes individual's personality, respect to individual's personality also. So dignity of the individual, fraternity needs to assure. Then unity and integrity of the nation. Now, this term, integrity, was added in 42nd Constitutional Amendment Act 1976 along with socialist and secular. Unity and integrity includes psychological and territorial dimension. We want India to be united territorially also, because states don't have the right to secede. We want India to be united psychologically also. That is, we don't want to fight on the basis of religion, race, caste, etc. So psychological unity we want, as well as territorial unity that is desirable. So this is the meaning of the word fraternity. We have discussed all the objectives which we want to achieve. Now we are moving forward towards the next aspect of preamble, which is a preamble a part of constitution? Hello Satish, is preamble a part of constitution? We need to discuss two landmark judgments in this aspect. Berubari and Kesavananda Bharati case. Now, Berubari is a place in West Bengal and it was a disputed area. So India and Pakistan were fighting over it. So the case came to Supreme Court and Supreme Court gave its judgment, where the article in question was Article 368. That is power of amendment of Parliament. So in this case, what Supreme Court said is preamble is not a part of the Constitution. Parliament has power to amend the Constitution, but preamble is not a part of the Constitution. That's why Parliament cannot amend the preamble. That was the case. That was the judgment, and the judgment came in 1960. After 13 years, a case arose, which was Kesavananda Bharati case. And here Supreme Court ruled out that the previous judgment was a mistake and preamble is a part of the Constitution. By that rationale, preamble can be amended by the Parliament. Preamble is a part of the Constitution. That is what Supreme Court said in 1973. Supreme Court pointed out that when preamble was added in the Constitution, like every other part of the Constitution, it has been voted upon, it has been debated. So by that rationale, it is a part of Constitution itself. But Parliament cannot amend the basic structure of the preamble or the Constitution. So preamble is a part of the Constitution. Preamble can be amended by the Parliament. That is what Supreme Court said. But there are few limitations to the amendment power of the Parliament, where it cannot interfere with the basic structure. We'll discuss the basic structure doctrine in one of the lectures. But at the moment, I just want to share you this. If tomorrow Parliament wants to remove the word secular and add the word theocratic or a religious state, it is not possible, because it is against the basic structure of our Indian Constitution. So Supreme Court said that Parliament can amend preamble as long as it doesn't disrupt the basic structure of the Constitution. So two landmark judgments. Berubari Union case said that preamble was not a part of the Constitution. This has been revised in this case, and now the ruling said that preamble is a part of the Constitution. Moving forward, We need to remember few more points with respect to this thing. Preamble is not justiciable. We have seen that economic equality is a part of preamble, but preamble is not justiciable. That means in the court of law, it can't be enforced. It is not a source of power for the legislature nor a prohibition. Preamble is not a source of power for legislature. Neither it prohibits the legislature or restrict it. And it can be amended by the parliament. This we have discussed. Now let us solve some questions. The preamble of the Constitution of India is, this has been asked in the year 2020. Come on guys, this is the last question. I want everyone to answer this one. The preamble of Constitution of India is a part of the Constitution but has no legal effect. Not a part of the Constitution and has no legal effect. A part of the Constitution has the same legal effect as any other part. A part of the Constitution but has no legal effect independently of other parts. Okay. A is not the right answer. Read all the options carefully. Okay, so the answer is D. Because preamble is a part of the Constitution but has no legal effect. It is true, but it has some of the features being implemented through other parts of the Constitution. For example, equality. Equality is mentioned in preamble, but we have right to equality also, which is justiciable or enforceable. So a part of the Constitution, preamble is, and we have seen the case also, but it has no legal effect independently of other parts. Because individually, if we go that it is written in the preamble and Supreme Court should implement it, but it may not be the case. But with respect to some other acts, they can be implemented. So the right answer for this question is D. Hope you got it. People who have answered it wrong, hopefully you have understood this. With this, we have come to the end of our chapter. Preamble we have discussed thoroughly. If you have any question with respect to that, you can let us know in the comment section. And I'm assuming that you are finding these sessions informative. So like, share, subscribe to this channel. Thank you.